So we have few cases for today as well. We'll continue with that, okay? All these are again Supreme Court cases that we will see. Now, in case of contract, if you have read that part, that what is Contract Act all about? What all things do we get inside Contract Act? Anyone? Indian Contract Act, if we talk about it, what all things do we get inside Indian Contract Act provisions? Agreement, conditions to enter into a contract, definition, yes. What else? Is there anything that we get related to clause, like what clause can be there, what clause cannot be there, how to frame a clause? Okay, consequences for breach of contract, correct. Okay, so what is it mentioned about clause? What is the clause? Is it defined in Contract Act? No, correct. So it is not defined as such. I'm asking, what is a clause actually? Okay, you are asking. Okay, I thought you are saying that it's defined what is a clause. So clause basically means what is written. Like, have you seen any sort of things where these terms and conditions would be written? Like if you want to download some software, there also you would see right before proceeding, there would be a lot of terms and conditions where you need to just press accept and then proceed. You have seen. Same ways you would see there are some offers would be going on, all right? Take for example, if you visit a mall, there would be some offers, right? Like 50% off. But when is this 50% off applicable? Only until stock lasts, right? So that thing is nothing but a clause, as in some of those terms and conditions which we have, right? Those are nothing but like clauses of the contract or the agreement. All right, so it may be that if you shop for 5,000 rupees, you will get a gift voucher of 2,000 rupees. So that's nothing but a clause. After that, they would again, yeah, terms and conditions. Same way in a contract also, there would be a lot of terms and conditions, a lot of different clauses talking about different things. Okay, like liability of parties, compensation, validity period, so many things will be mentioned. That's nothing but a clause. Now, Indian Contract Act, if you look at the legislation, as such, it do not mention anything about a clause. Okay, it mentions what are the essentials for a contract. It provides for all the definitions and stuff. Then it says these are the essentials which we need for formation of a valid contract. That means once we fulfill those conditions, the contract will be considered as valid, and that's enough. But what are we writing inside these different clauses? We are completely free over there. Okay, we can write whatever we want because both the parties would negotiate, right? If you are okay with the clauses, then only you would accept. Otherwise, you are free not to accept the contract also. Okay, clauses nothing but those terms and conditions, and Indian Contract Act as such do not mention anything regarding these terms or condition. It just says fulfill these essentials and do not put something which like goes against the law or public order, morality and all that stuff. That's all. And that's why mostly we are free to put clauses based on our own wish. Okay, now there are different types of contracts. One is called the standard form of contract. Can you guess what is a standard form of contract? The name itself explains it. Anyone? Fixed, correct. So it is nothing but a fixed, like a format is there, though it will not be changed. Like take for example, if you want to apply for, maybe if you want to open a bank account, okay, if you want to open a bank account, those terms and conditions will be same, right? If there is like a minimum balance you need to maintain, that clause will be there only. Bank will not ask you, okay, what all things do you need, right? Bank will say these are the few options we have, just select one that fits your requirement. Same ways, when we are downloading a software, that software company will not call us and ask, okay, what are the terms and conditions you want, but they will say, this is a big list of terms and conditions, do you agree or not? If you agree, you can proceed and download the software. If not, just leave it, right? That means it is standard form of contract wherein one party, okay, one of the parties will have a fixed contract format, and they are not willing to make any changes in that. Same ways, in between companies also, you would see if there are two companies, one of the company would say that we have a contract, we have a standard form of contract that we will be providing you. You read it, you fill it, and we would enter into a contract. Okay, so that is what happens usually. Now, this standard form of contract is applicable especially when a, a company or a person as such enters into similar contract with multiple people or multiple entities, right? If there is a company who is providing for some kind of a service, maybe providing for drafting services to other companies, they are having multiple clients, and with each client, they don't want to sit and negotiate the terms or conditions, but they would simply say, this is the, like the standard form of contract, these are the charges that we make, so just read it. If you agree, fine. If not, go ahead. If not, we are not going ahead, right? So that is nothing but the standard form of contract. Same happens in case of builders also. Nowadays there are so many apartments being constructed, right, wherein builders would take the property, like builders would basically buy property, like a big area of land from maybe individual owners, and their builder would get the permission, approval and everything, and they would start with the construction. And you would see builders will make all the promotions everywhere that we have this 2 BHK, 3 BHK, this price, that price and everything. Now, once someone approaches the builder and says that I really like this flat, I want to buy this. In that case, builder will not ask that, okay, how do you want to proceed? What all terms or conditions? But builder will say, this is the agreement. Take it, put your signature, make the, like this amount, deposit you make, and then we can proceed with it. That means builder is having a standard form of contract because they have constructed so many floors with so many people they would be entering into contract. So they will simply give that. If you accept it, let's proceed. Otherwise, not. Now, in that same contract, what all conditions, what all clauses they are putting, they are free to put that, because Indian Contract Act has not mentioned how we should frame a clause. What can we write, what we cannot write. It simply says just fulfill the essentials for validity of the contract. That's enough. Now, what happened in this case? We would discuss it. Okay, so there was this is a case from Gurgaon. There was this big area of land which was bought by this builder, and they obtained all the permission, approval, like it also involves a big process, right? They would need to take approvals and NOCs from so many government departments, right? Municipalities, fire, this, that, so many things are there. After taking all the approvals and everything, their building plan should be approved and all that, they will start with construction. And once construction is almost done, they will apply for occupancy certificate, wherein the concerned bodies would come and they would say that, okay, fine, all the things you have followed, now like people can come, your buyers can come and really stay in this property. Okay, so what happened in this case is, there was this builder. They constructed this apartment in Gurgaon. So once they got the permission and everything, right, they started with the promotions everywhere. They were promoting that we are constructing these 2 BHK, 3 BHK and everything. And during that process, Abhishek Khanna, he came across this promotion and he came to visit the flat and he really liked it. So he thought that, okay, fine, I will buy one of these apartments. Okay, so he bought a plot over there and then some advance amount had to be paid. So he made the advance amount as well. Okay, he made the advance amount as well. But now, because it involves so much of, like processes, so many NOCs, so many this, that everything has to be done by the builder, it took a very long time for them, because again, government is involved, right? All the process, everything should be done properly. So it was taking a very long time, which you would see again, mostly you would see, right? Half constructed apartments would be there. Some violation they have done, this, that. Sometimes it's completely like injunction order, only court would pass that this is an illegal construction, you cannot go ahead with it. And so many reasons. Because of so many reasons, it gets delayed. So in this case also, and in the agreement, like I said, there would be different clauses, right? In agreement, they would also mention that this is the time when we are planning to hand it over to you, right? Like by maybe May 2022, we are planning to complete this entire project and it will be ready for you to like move in. You can live here after that point in time. Like that also, there will be one clause in such agreements. Same ways, they also entered a clause wherein they said that this is the time frame when we are giving you possession. You can just come and you can stay here. Okay. Now this case which we have, it was filed in the Supreme Court of India. It was decided by 3 judges bench. Now what is this case all about? There in the agreement, right, they had mentioned 42 months. Okay, what was the period mentioned? 42 months plus 6 months of grace period. Usually it is very difficult to promise a date, okay, for these kind of projects, because it involves so much of formalities and a lot of work needs to be done. So there will be a grace period as well. In this case also, they said 46 months. We are planning to complete this project and hand it over to you, but there may be 6 months of grace period. If because of anything it gets delayed or something happens, this is also the time which we have. Okay. In the agreement, if you see, they have mentioned so many clauses, like this entire payment would not be like done at once, right? Because this is still under construction. So whoever is buying it, they would make the payment like part by part they would make. Okay, so this entire flat, the flat which Abhishek Khanna bought, it was some 1 crore, some 1,000 rupees. Okay, he also made some amount over there. Then there were clauses like, if there is delay from your part in making the payment, there will be this 20% interest charge, this, that, like that, all the provisions were there. Now what happened here is, the purchase agreement prevented buyer. They had mentioned that, okay, fine, this is the time frame when we are planning to complete it, plus 6 months of grace period. from the buyer side, if there is any delay or anything, buyer need to suffer like huge penalty, okay, like 20% of interest and everything. From their part, they kept it very much like in their support, because it was a standard form of contract that the builder had drafted. So they also mentioned that this is the period, but the purchase agreement prevented a buyer from terminating until 12 months after expiry of 42 plus 6 months period. That means, fine, we are making a promise to complete it within 42 months. If not, 6 months of grace period also is there. But even after this, if we are not able to like hand it over, then until 12 months there is this thing, right? The prevention is there for the buyer. There is this prevention that you cannot uh, terminate this contract. And for the restricted compensation for delayed delivery up to 7.5 per square foot per month for a period of 12 months. First 12 months, you cannot sell it. Next 12 months, this is only the compensation. That means everything was in their support. For the buyers, there was a huge penalty which was imposed. But if there is a delay from the side of builder, then it would be like very less amount. For 12 months, you don't have the option of terminating also. Okay, now when a buyer is buying an apartment, he will have this thing in mind, right? That within 42 months it would be completed. Based on that, he will plan his financials as well. So when it was not delivered on time, plus there was a clause in the agreement itself which prevented termination of the contract, the buyers were suffering very badly. Because of that, they were undergoing too much of difficulty that they could not do anything. So this buyer was not happy with this thing, the service provided by them. So he decided to go and file a case in the consumer forum. Okay, so are you aware this consumer forum, how it works under Consumer Protection Act? How many bodies or forums do we have? Anyone? Consumer Protection Act. I think previously we had discussed one case related to consumer forum. Anyone? How many forums or how many levels do we have? 3. Okay. At what all levels? District, state, and national. Correct. So under consumer, yeah, you are correct. So district, consumer, and national, district, state, and national, we have these 3 levels. Now, because this buyer was not happy with the services provided by this builder, okay, he decided to go to consumer forum. We would go to consumer forum for either if we are not happy with the service, or if we are not happy with some goods that we have bought. In this case, it was service. Because it was like an old case when it was initially filed in the commission, right, before the commission. So that's why you would not see this provision. Okay, like Consumer Protection Act, there are some changes made right now, but it was like filed in the National Commission, because this amount is like 1 crore or above, right? So National Commission, this person went. So developer said that National Commission did not have power under Consumer Protection Act to nullify terms of the condition. National Commission said that this clause that they have mentioned, this builder, this clause is one-sided clause. It is just talking about their benefit, it's just supporting them. Such kind of clauses should not be there in the contract itself. Okay, so National Commission said that this is not valid. So directed developers to refund the installment it had received along with 10% interest per annum. However, like whatever amount they had received from the buyer, National Commission said that you need to return that amount because there is unexpected delay from your side, and in the contract itself, you have added a one-sided clause. So you need to return it to the buyer along with 10% interest per annum. So that would again make the amount a big amount, right? So builder was definitely not happy with whatever decision was given by the National Commission, and they decided that no, we are going to move to the Supreme Court of India. So they went to the Supreme Court, and in the Supreme Court they said that no, this decision which was taken by National Commission, that's not valid. How come National Commission can just nullify a certain clause? How can they say that this clause itself is not valid? Okay, so when the case was filed before Supreme Court, they refer to these two clauses. These clauses are from the old legislation. Now we have Consumer Protection Act 2019. Okay, but this earlier one was referred because like at this National Commission, right? Before National Commission, the party went few years back, right? So that's why at that point in time, this legislation was effective. So under this section, it talks about unfair trade practices, and it also talks about what all things are unfair, right? So unfair contract is also mentioned there. If you look at the Consumer Protection Act, it provides that power. So Supreme Court looked at that, and Supreme Court said that this can be declared as null and void. That is only a statutory recognition to the power. So whatever decision the National Commission has given, that decision is proper only. They have that authority under the legislation. Supreme Court said that delay in delivering possession amounts to a deficiency in service, entailing the buyer to receive a refund of the money. Because there was so much of delay, buyers are now entitled to get refund of their money with reasonable compensation also, because their money was there with the builder, right? They would have earned heavy interest otherwise. So builder was also asked that you need to pay 10% interest on whatever amount you have received. So in conclusion, Supreme Court said that whatever order this National Commission has passed, that order is valid. Even though Indian Contract Act has not as such said anything related to clauses, that does not mean that this party, right, who is like in a better position to negotiate, because builder is more entitled to frame the clauses, right? Buyers, if they are interested, they would anyways want to buy it. So they said such one-sided clause, they do not make a sense, and National Commission, National Forum was right in taking that decision. It should not happen that all the clauses are in their favor, plus there is like a long delay in delivery of possession. In that case, buyers are going to suffer. So if they want to terminate the contract, if they want to like end this contract, they don't want to proceed with it, in such a case the developer should give it, because it's a fault from their side only, right? They are only delaying the entire project. That is what this case is all about. It's important because we are anyway studying contract, right? And there we talk about different clauses, different types of contracts. So this becomes important, that one-sided clause in a contract can be like removed as well. It is not a valid thing to do. It's just like taking advantage of their position, their ability to negotiate with the other party. Okay, is it clear? And this is the apartment related to which it is. You can even see this is addresses. You can just type this name, you would see the flat and address and everything. Yeah, it's in Gurgaon only. Okay. Next case we have is Rama Narag versus Ramesh. It was again of 2021, and cases related to willful disobedience is contempt. So what is contempt? And looking at the picture, it's like contempt of court. What is
like insult or something?
Insult. Okay. So what is contempt of court?
When you insult a judge or a court or their decision or something.
Their decision or something, correct. When you disobey court's authority, correct. So that is willful contempt. So what are the types of contempt? Types, anyone? There are civil and criminal contempt. Okay, and when we say civil and criminal, like take for example, in certain types of crimes, they would be criminal only. Like murder cannot be civil. Okay, rape cannot be civil, kidnapping cannot be civil. Same ways, there are certain things which are civil only. Okay, in like there are certain things which are civil, there are certain things which are criminal. Same ways, there may be certain things which may be civil or criminal, like in case of defamation. Okay, party is free to decide, like the victim is free to decide whether he wants to proceed with a civil suit or a criminal proceeding. At the same time, there are certain things which are both civil and criminal, but it depends on how was it committed. Okay, depending on that, we will take a decision whether it's civil or criminal. So take, for example, in case of contempt, right? Contempt may be civil also, it may be criminal also. But it does not depend on the victim that if he wants, he would proceed with a civil suit. If not, he would go for a criminal one. No. We need to see what was done. Like one of you said, insulting the court, insulting a judge, disobeying court's authority. Like that, we need to see what was done in that specific situation. And based on that, we can say whether this contempt was civil or criminal. So for contempt of court, we have a legislation also. And that legislation provides for definition as well. Okay, definition of what is a civil contempt and what is a criminal contempt. And based on those ingredients, we need to see. Yeah, so see, what is civil contempt? It is defined under section 2B. Willful disobedience to any judgment, decree, direction, order, writ, or any other process of the court, or willful breach of an undertaking given to the court. Criminal means any sort of publication, any matter, doing anything whatsoever. Like this Prasant Bhushan case, that was criminal, right? He had posted something on social media. Like that, we would decide like what is being done. Based on that, is it civil or criminal? So in this given case, it talks about willful disobedience is contempt. And where we are getting willful disobedience, we are getting it in civil, right? So that means this case is related to civil contempt. Willful disobedience is civil is contempt. So in this case, what happened? We would see that. All right. So in this case, right, it was like a related to family settlement. All right, there was this father, it's like father versus sons. Okay, so there was this family settlement which was going on, like this father and the mother of these two sons, right? They were married to each other and then they got divorced, they got separated. After that, there were some family settlements. Okay, there were some family settlements that had to be done. So in those family settlements, it was arising from first wife. From his first wife, he was having these two sons, and amongst them, these three, some settlements had to be done. And in this family settlement, when the case was filed in the lower court for the settlement, right, there was this hotel which was there, and its subsidiaries, whatever was falling under that parent organization, those were given to these three people, like the father and his two sons from the first wife. It was given to them, and they were to be the only directors. They will be the directors of this certain hotel based on the family settlement. Now, how did the family settlement happen? It was by way of like arbitration. They all sat together, decided, came up with proposals and everything, and then finally it was done. Okay. Now, further, it was added that any decision of the board of directors, they were the directors, these three directors, right? Now, any decisions that they wanted to take was to be taken by mutual consent. Okay, mutual consent of father and this sons which he was having. Okay, so there had to be mutual consent of these people. Plus, though if the amount of any transaction was exceeding 10 lakhs, then the same could not be undertaken. Then the same could be undertaken only through a check signed jointly by the father on one hand and the sons. Like either of the sons will have to put his signature, and the father. Like signature of at least two directors would be needed to do these sort of transactions more than 10 lakhs rupees. Now, what were the allegations in this particular case is that the father said that the sons, right, they had violated terms of consent order. So what is consent order? Any idea, anyone? Like I mentioned, right, for this family settlement, they went for arbitration. In case of arbitration, what happens? It's not like a judge sitting over there just giving a decision that we need to obey. Consent is giving approval. Yes, consent is giving approval. So when we talk about arbitration, what happens there is parties would also propose something, right? They all would agree, they all would come to one point, and then only it would be decided. That is nothing but consent order. Everyone agreed to it. After that, only order was passed that becomes binding, right? So there was this consent order based on the arbitration that happened between them. So arbitration order, there were certain clauses like clause 3, clause C, D, E, F of minutes of the consent order. So those were violated. According to the father, sons have violated this, all these clauses of minutes of the consent order. And violation of the same order, it amounted to disobedience of the order what was passed by the court, and thus it falls under Contempt of Court Act, like the definition that we saw, civil contempt. It falls under Contempt of Court Act because this minutes of consent order, this consent order was passed under the authority of law. So that if you are not obeying, that again falls under Contempt of Courts Act 1971. But now what happened over here is that there is company law board, okay, that due to differences amongst these directors, many operational issues were there, like they were not able to pay salaries to their employees. Certain payments were also pending to the suppliers. And because of that, all the employees were like protesting and things were not going good in the organization. Because for 10 lakhs rupees also, they would need approval of all the directors and everything, right? Two directors should approve. So payments were not getting cleared. That is why there was a lot of issue that was going on inside the company. And company law board found it appropriate that till petition was disposed of as an interim measure in the interest of company and all the employees who are there, there should be a mechanism by which day-to-day operations of the company were carried on without any sort of problem. Like this approval, the sanction, it's not coming in. So just in order to ensure that day-to-day operations can be done properly and smoothly without any sort of problem, so some steps need to be taken. And the father said that this company law board order was violative of the order of Supreme Court and nothing but an attempt to legalize their conduct by contempt. So whatever the sons were doing, that is not valid, and company law board should not come in between, and they should not like interfere in this entire thing, right? Because already there was this consent order, everybody consented and everybody came together and they were following it. So after that, some third body should not come and should not intervene. That amounts to contempt of court. Like it is violating, right? Sons were not following the rules, so that falls under section 2B of contempt act. Civil contempt, that is willful disobedience of a judgment. So the father mainly said that invoking jurisdiction of CLB and entertaining the said proceeding by company law board itself amounts to contempt. Why are they coming in between? They should not come in between, because there is already a consent order that's there, and that consent order should be followed by all the parties. In contempt proceeding before the contemporary, it held that guilty and punishable court would record the findings. Now, Supreme Court said that this contempt thing, what we are mentioning, right? It talks about willful disobedience to any judgment, decree, order, etc. Willful thing is very much important. It should not be that you don't have any other option, but the situation is such that you are just opting for all the options which you have. Like in case you are looking at companies law, companies act, there you have this provision, right? You can approach the CLB. So that's why you are approaching. So just approaching or seeking help from all the options that you have, that would not amount to contempt. Plus, unless and until it's like willful disobedience, willfully with your knowledge, if you are violating, that amounts to contempt. But if you are violating that consent order just in order to get this option also, right? Just in order to make use of this option also to approach the CLB, that does not amount to contempt. Okay, so what court said, Supreme Court, what did they say is willful disobedience is contempt. Whoever is accused of contempting, right? They should willfully disrespect or disobey the order or judgment of the court. Only in such a case it will be contempt. But sometimes the situation may be such that in the interest of all the employees working in the company, all the suppliers and all the other people dependent on the company, they have to make use of all these different options or reliefs available in law, right? So just in order to apply or get help of all these reliefs, if you are not obeying the order, that does not amount to contempt. Basically, like you have a justification that you can give, right? That under law, I also had this relief, so I wanted to make use of that first, and after that I would, like follow it, whatever order is there from the court. So that would not amount to contempt. Is this part clear? It involves a bit of this company law thing, but yeah. Yeah, they were not held guilty for contempt in this case. Actually, this is a very like a lengthy process. If you see this judgment, right, there are multiple cases which are pending also between this father and sons and everything. Like there are so many people involved, right? Because second time also he got married, there also kids are there. Amongst this family only, there are so many settlements, so many businesses, this, that. Lot of cases, in fact now also few cases are pending. So for this case, yes, the whatever the sons were doing, that was not considered as contempt. Is this part clear? Yeah. So in this case, right, again, this case in itself is having so many things, right? First of all, some civil suit was filed, there they were not happy with it. Then they went for arbitration. In arbitration, this consent order was passed that they had to follow. After that, they thought of approaching this CLB. Now, why did the father think that it is contempt? Is because when we talk about contempt, like civil contempt, disobedience of order or judgment of a court, whether it is the regular courts, whether it's of arbitration, it is some order that you have obtained from the court, right? So when you have an order obtained from the court, ideally you should follow that, you should respect that, you should abide by that. Okay, so father was also expecting that, yes, because we have this arbitration order, the sons should be following that order, they should be abiding by that order. But rather what they did is, rather than following that thing, they approached CLB. So you should not approach CLB because you already have something that you should abide by. If you are doing that, then it's like disobedience, you are not respecting that consent order which is already there. That's the reason why father thought that because they approached CLB, it amounts to contempt. But court on the other side said that no, this was not willful disobedience. They had the option of seeking help from that CLB, they did that. So it was not like they intentionally wanted to disrespect the court or not to follow the order, but rather they were just making use of what provision they had. Okay, so it does not matter who was involved. Was it this company law coming in? Is it some people, something? What we are concerned is disobedience, right? That is how the father thought and filed the case. Next, one more case we have relating to mutation. So this case is related to property law. Okay. Now, last class also we discussed something on like property, right? A case related to property discussed. Yeah, transfer of property. There also we saw that there may be act of parties or by operation of law. When we talk about act of parties, it may be by way of testamentary or non-testamentary, right? Non-testamentary, when we talk about this transfer of property act comes into application. All right, transfer of property act that talks about different modes of non-testamentary alienation or transfer of property, which will be by act of parties. Now, this transfer of property act, it mentions the rules and regulations that we need to follow for each type of transfer. Okay, let's take for example, there is sale, there is lease, mortgage, exchange, gift, so many different ways we have, right? And it's not like the same process is followed everywhere. There are different processes followed. Like take for example, in case you want to sell a property, because this legislation is like very old, it says that if value of the property is like 100 rupees or more, registration is must. That means if you have not registered the property, it is not a valid transaction in itself. Same ways for lease, method is different. In case anyone knows what is lease all about, and is registration needed or not for lease? What is a lease? Where you rent out a property. Is registration needed for lease? No. Okay. If the duration is more than 11 months, then registration is needed. Okay, otherwise not. So like that, there are different things, right? Like in case of sale, we are deciding on the registration thing based on value of the property. In case of lease, we are deciding it on the duration. Okay, like that, there are different conditions. And Transfer of Property Act makes it very clear that whatever rules are mentioned, right? If it says registration is needed, this is needed, that is needed, all those rules need to be followed. Only when you have satisfied all those conditions, your transaction will be considered as valid. Otherwise, not. Okay, so only when you have followed those rules and regulations, your transaction would be valid. Now, what is this case all about? We'll see that. Okay. Now, also, when these transactions happen, okay, like take for example, if you are owner of a property and you want to sell that property to me, there would be like government records for each property as well, right? Where government would have records of who is the owner of property, who was the previous owner, who paid property tax, and so many details, right? Same ways, there is something called as mutation. Anyone heard this word before, mutation? In terms of transfer of property, okay? Actually, mutation means mutation of property is nothing but transfer or change of title entry in revenue records. That means for every single property, right? Usually the local municipal corporation, sometimes it may be the Gram Panchayat, those bodies would be having like some revenue records also. Okay, they would be having some records that who is owner of the property, are they paying property taxes or not. They would even have some sort of, what do you say, that like a blueprint of it, like how the property looks, what, like a map sort of a thing also they would have, which clearly indicates everything. All right, where there is a road, there is a maybe lake, this, that, everything would be indicated. So those revenue records would be kept with the municipal corporation, panchayat, and the concerned body basically. And when a property gets transferred, like if you want to sell your property to me, title entry has to be changed, right? Because you were mentioned as owner in the revenue records. Now my name has to go because I have purchased the property from you. So mutation is like a very important process that is being done. And once it is done, right, then the change of title and ownership may occur due to number of reasons, like death of original owner and subsequent inheritance, succession, sale of the property, and so many other reasons. Now, when I had get this, yeah, this is the mutation certificate. Once mutation is done, right, you will also get a certificate. This is how the certificate would look like. That would give details of the property, like what property have you bought, plot name, some khasra number, moja, khata number, survey number. These numbers like differ from state to state. Like that, they would just provide the indication and everything. It will also be provided to you. That is nothing but mutation. So this case talks about mutation does not confer title. Now, what is title? What do you mean by title? owner of the property, correct. Title means ownership of the property. So that means mutation does not confer title. Just because mutation is done, just because you have got the mutation certificate, that does not confer title on you. That does not indicate that you are the owner of that property. Why? Because mutation is simply an entry made in the revenue records. For the purpose of keeping records, they have just made an entry. That does not confer title. But what confers title? All those clauses and conditions mentioned in Transfer of Property Act. Like I said, for 100 rupees or more, registration is needed. So if you have done the registration, paid the requisite fee, got the thing registered, then only you become owner. Then only title would be conferred. So mutation does not confer title. Okay, now what this case is all about? This is Commissioner BBMP versus Furaullah Khan. This again is from 2021 only. Now what happened in this case is there was this title suit. Okay, title suit as in this for property matter on and all, right? It's like original suit. They approached the court and then they filed a case to decide like ownership of this property. So this case was going on between petitioner and a charitable trust, where the title to the suit is under adjudication, as in they were still deciding on the matter. And there were some other matters there in the High Court also. So High Court had ordered, okay, High Court had ordered BBMP to do this mutation of this particular property. All right, now mutations are needed for the purpose of revenue payment and everything also, right? To pay property tax and all those matters, it is needed. Those things are required. So High Court had ordered BBMP to get this mutation done. Now in this particular case, this was like a case before Supreme Court of India, wherein Commissioner of BBMP filed this case against this person. Right? And this original case was like this person versus the trust under like the title had to be decided who is owner of this property. Now in this case, Supreme Court said that just because mutation was done in name of this particular person, that does not indicate that he is owner of the property. In order to establish that, because so many times, right, title on the property is only in question. Who is the original owner? Who is the lawful owner of a certain property? That thing itself comes in question. So in such cases, court takes a decision on that based on so many other factors. So court said just because mutation was done, that does not confer title, but it had to be decided based on all the other factors that we get. Okay, so just because it is given as a remedy, that will like not be considered as conferring title to the person. Is this case clear? These words you would be getting a lot when you study property law as well, right? Survey number, khata number, mutation certificate, this, that, so many records would be there over the government departments. So we have this last one more case that we will see. Okay, this is Balwant Singh versus Sudarshan Kumar. Again, Supreme Court of India, a civil appeal. For different states, right? All the states are having their own rent control acts. Okay, some might be like this Eviction Act, Rent Control Act, like we have your like Karnataka Rent Control Act. Same ways for Punjab, it would be different. For other states, it would be different. All right, now under this Rent Control Act or eviction laws, it provides for the rules or regulations that need to be followed by the landlord as well as the tenant. Okay, what all terms or conditions should be there, because so many times we see there is clash between landlord and tenant, right? They all think about their own side. They don't think about the other, like from the perspective of the other person. So a lot of times there are disputes. That's why these land laws, this rent control laws, they help us to settle the matter. Okay, so usually those laws, legislations also provide for eviction as well. Okay, that, take for example, you have a plot of land and you want to rent that out. And I was also looking for a plot. So I went to you and I said, I'm interested to stay there as a tenant. You also said, okay, fine, stay here, pay this much amount of rent. Now, because of any reason, if you are in need of that particular plot, okay, maybe you are having some family function and you need like a bigger space, or maybe because of some other reason, for business, this, that, so many other things. Okay, if you need that plot of land, how are you going to proceed with the eviction? How are you going to ask me to vacate the plot? Like, you can simply ask me, vacate the plot. But what if I object to that? Because there will be a term of agreement as well, right? We would mention this, that, and all that stuff. So what is this eviction proceeding? How can you like proceed with that? All right. So what happened in this case is that the appellant Balwant Singh is owner of premises and 2 shops therein, for which eviction proceedings were initiated against the tenant. Basically, what happened, I'll just tell you. Okay, so there was this Balwant Singh who was having, okay, in a certain area, he was having 4 shops. All right, shop 1, shop 2, and shop 3 and 4. Now, 2 of these shops, right, he only was the owner. These were like next to each other. 2 of these shops, he only was the owner. And for this remaining 2 shops, he had given it to a tenant. Now, this owner decided that what I will do is I am going to start a business. Okay, furniture business he wanted to start. So what he will do is sell, purchase, manufacture furniture. And for that purpose, he needed like a bigger space so that he can do all the stuff. Plus, he wanted to renovate this entire space and make the necessary changes, whatever would be needed to start with this furniture business. So he said this tenant that you need to vacate this 2 plot of land because I want to start with this business. Same way, eviction proceedings were also started. But this person, right, the tenant, he said that why this person needs these 2 shops also. He just want to start with this furniture business, right? For that, this space is only enough. Why do we need these 2 space, like shops also? This space is sufficient for him to start with the business. So I don't want to vacate the plot. Okay, so that was the main thing. Like, tenant was justifying how much of space the landlord would require for his own purpose, right? And when this matter went before Supreme Court said that tenant should not be taking a decision. Limit to businesses not. The adequacy or otherwise of the space available with landlord for the business in mind is not for the tenant to dictate. Tenant cannot take a decision over that, because this rent control laws, eviction laws, they already mention for a process for eviction. If that process is being followed, then landlord can ask the tenant to vacate the plot of land, whether it's for some business, for some family function, for some personal reason. Tenant should not come and like be justifying that, okay, this much space is also enough, why do you need 2 more shops and stuff like that. Okay, so tenant is no one to take a decision over there. If landlord wants the shops and he is following the process, he can ask for eviction as well. He can ask the tenant to like vacate these places as well. Okay, is it clear? Balwant Singh versus Sudarshan Kumar, 2021 case. Okay, fine then. So for your own specific state, you can even look for the rent control law, whether they're like, if you are from Karnataka, fine, it's Karnataka Rent Control Act. If you are from some other state, you can see what is the rent control law that is applicable, because that varies from state to state. Okay, so fine then, with that, we'll end this class. Thank you, everyone.